SJC-13338, Commonwealth v. Nicholas Desiderio.
Okay, Attorney Miles.
Good morning, Your Honors. May it please the Court. Mary Miles for the appellant Nicholas Desiderio, who is here with me today. Instructions to a jury that lowers the Commonwealth burden of proof is an error of grave constitutional importance. In this case, it is undisputed, and the Commonwealth concedes that the trial court failed to tell the jury that it was part of the Commonwealth's burden under a theory of joint venture to prove that Mr. Desiderio had knowledge that the perpetrators, or at least one, was armed en masse under the charges of armed en masse robbery and home invasion. This error created a substantial risk of a miscarriage of justice, where the Commonwealth's circumstantial evidence was not so overwhelming that there was no likelihood that this error did not materially influence the verdict. Or put another way, that the verdict required the jury to ineluctably infer that the Commonwealth had met its burden of proof as to the admitted element. My client's presence at the scene of the crime was highly disputed. There was no description of the getaway driver. There was, let alone a description that matched my client. There were vague and inconsistent descriptions
I thought this was more of a whodunit than a what did they do. As I read the record, I thought to myself, this is really a difficult case of circumstantial evidence as to who the perpetrators were, not what they did. And what they did was clear that they were both armed.
I think as to the principals, absolutely. There was no identification as to the perpetrators by any of the victims. The Commonwealth's evidence as to the principals being my client's co-defendant, Timothy Lavin, was circumstantial. The question
I was trying to figure out why didn't the defense attorney catch this, and I think probably the focus was on you didn't prove, this is a mistaken identification case. My guy didn't have anything to do with this case.
As well as my client, in addition to my client's, the alleged participation of my client in the home invasion and my client's presence at the scene. The majority of defense counsel's closing argument, as well as cross-examination, had to do with this CSLI evidence that the Commonwealth put forth.
That he wasn't there.
Yes, exactly. I mean, that was the defense counsel's argument. The defense counsel at the end of his closing argument did also mention that the Commonwealth was required to prove that my client, Mr. Desiderio, shared the intent and knowledge required of those crimes.
So why is Justice Ditkoff wrong?
In terms of why this didn't create a substantial risk of miscarriage of justice?
I mean, we took the case, obviously, to look at the harmless error standard.
Correct.
So why was the majority right and Ditkoff wrong?
Well, I think that's, so Silvella was clear that in this court reaffirmed the standard enunciated in Azar and then enunciated again in Bowling and kind of held throughout its progeny that if the jury is not in the context of an omitted element context, not the context of a prosecutor's closing argument or bad act evidence or prejudicial evidence, but in the context of the lowering the Commonwealth's burden of proof, then in that situation, the court has to ask themselves, was the jury required to find, in finding the defendant guilty, was the jury required to implicitly find that the Commonwealth met its burden as to the omitted element?
Is joint venture an element of a crime?
No. Joint venture itself is not, but...
Joint venture is a theory of accomplice liability, correct?
Yes, so, but it is required, and this court, as well as the appeals court, has held numerous times, I believe it's pretty well settled that the part of the Commonwealth's burden under a joint venture theory is that the Commonwealth has to prove beyond a reasonable doubt that if the co-venturer is not armed or masked himself, that he was aware and had knowledge, which is one of the elements of a joint venture, that he had knowledge that one of those principles was armed.
An element of accomplice liability. Right.
Yes, that they prove that he had knowledge of that underlying, the intent and of that underlying crime, correct. So in that situation, the way the trial court instructions had been sent to the jury is they could have found him guilty just as a perhaps, if there was, which my clients and I strongly disagree with, if they had presented sufficient evidence that my client was involved in planning the robbery, he could have done so from Worcester. He didn't necessarily need to be present at the scene of this crime. He could have given the perpetrators information of the house, could have told them about, the money in the safe, et cetera. He didn't necessarily, to find him guilty, the Commonwealth wasn't necessarily have to find him present.
Zanetti allows for that, though, doesn't it? Zanetti says that give the instruction and we'll figure it out on appeal, essentially, if there's sufficient evidence.
We have sufficient evidence doesn't necessarily mean that there a substantial risk of a miscarriage of justice cannot occur. I mean, this court, as well as many other appeals court cases, as well as this court, has held that just because any rational jury could have found that element does not mean that the omission of that element and the lowering of the Commonwealth's burden of proof did not cause serious doubt or could not have, or there was no likelihood that that materially influenced the verdict.
So I guess there are two issues, and I'll shut up after this. There are two issues. One is whether this is an element, and to invoke the rule, and then secondly, whether the rule makes sense, and we should have a different standard for elements of the crime.
I would, in terms of the element, I think to find that the Commonwealth's burden of proof is not required to say that the defendant doesn't have knowledge that the perpetrators are both armed and masked. I think you would have to overrule quite a lot of case law. Bowling, Azar, Gorman, Quinones, Palmer. I mean, there's a litany of cases under joint venture theory that it is part of the Commonwealth's burden of proof that they have to prove that this knowledge element. Otherwise, why instruct in the first place? Why is that instruction required in the first place? And second, wouldn't he then just be guilty of, in the terms of armed and mass robbery, unarmed robbery, if he doesn't have to have that knowledge? In terms of whether or not the standard is right, I would argue that the dissent in this case is, as the majority said, truncating these snippets from Bowling, from Spinucci, from Vatcher. What this court has done is really just enunciated the same thing over and over again. Is there serious doubt in this case? Is there serious doubt means was the evidence so overwhelming that there's no likelihood that this error materially influenced the verdict? While I know in the footnote 16 in Spinucci...
Is that the case? Because that's the standard for the missing element. It's
Correct.
Not the normal standard for substantial risk of miscarriage of justice. Right?
No, I agree.
Right. So you're saying we did change the standard of substantial risk for this element, missing element instruction. Right?
No, I think this, in all the cases dealing with a missing element, this court has been very clear, I believe, in Azar, dealing with malice instruction, whether the jury was required to find that the Commonwealth met its burden of proof as to the admitted element or ineluctably inferred.
Azar used the ineluctably inferred? I thought Azar didn't use the ineluctably.
Oh, I might have been mistaken. I think its progeny had used ineluctably inferred.
Yeah, so the question is, do we go back to Azar, or do we continue down the intellectually referred Desiderio line?
But then I would point this court's attention to footnote 9 in Savello. Didn't this court make clear that the standard that's so overwhelming that there's no likelihood of a materially influenced...
But I thought the footnote said, and I guess I promised to shut up, I'm not, but I thought the footnote said something like, these are just all semantic rephrasings of Azar.
Correct, yeah. So I guess that's what I'm trying to say, is they're all kind of saying the same thing. You really have to ask ourselves that, did this verdict of guilty, did the jury have to find that my client was aware that he had knowledge? Or, put another way, if the jury had been instructed correctly, that they were required to find that my client was aware that the principals were armed and masked, is there a possibility or a likelihood that they would have found for not guilty? And I would argue that the scant circumstantial evidence in this case leaves the doubt as to whether or not they would have affirmed their conviction if they had been convicted correctly.
What do you say to Justice Ditkoff's point that if this essentially blends, preserved error with unpreserved error, that it's the exact same standard if we adopt this?
I think it's an interesting point. We preserve an error or we object to jury instructions, right, so the court can get it correct, right? So more likely than not, if defense counsel had told the jury, hey, you're omitting this required instruction that the jury would find beyond a reasonable doubt that my client had to have this knowledge, the court would have allowed that instruction more likely than not, and we wouldn't be here. In this circumstance, dealing with the nature of the error, it is almost similar to a preserved error.
And
in
is
this
that
situation.
because of the constitutional nature of the error?
Absolutely, in the lowering of the
Because if
Commonwealth's
you
burden of
don't
proof.
require the Commonwealth to prove an element, that it may not actually be a crime.
Yes,
Or
exactly.
a different crime in this case.
Yes, and that's what Bowling said, exactly. So I think it's an interesting point that Dickoff points out, that it doesn't seem to be much of a difference in this situation dealing with an omitted element between an unpreserved error and a preserved error. But I think it's important to note that had the trial court been asked to give that instruction, more likely than not, almost no doubt in my mind, the court would have given that instruction.
But
He
does
just
that
was not
matter?
asked.
Let's just posit a scenario where the defendant asked for the instruction and the trial court said no. Then it's a preserved error.
Then
And I
it's
think
preserved
Judge Dickoff's point was that in that scenario, as unlikely as you think it may be, preserved error is being treated the same as an unpreserved error.
Well, in that case, we looked to whether or not the error was harmless and beyond a reasonable doubt. In that situation, then we would still look at whether or not the jury would have convicted, or whether or not there was any likelihood that the jury would have not have convicted if they had been, sorry, there's a lot of negatives, if they had been instructed correctly.
I'll have to listen to that one back on the tape.
But I'm just saying that the analysis is rather the same, just because.
And the reason it should be the same, perhaps, is because of the constitutional nature of the error.
Yes. As I said before, we're not talking about an improper closing argument, as the Alameda case in my Commonwealth that my brother points to in his brief. We're not talking about, prejudicial bad act evidence. We're not talking about, improper opening argument, that kind of thing. This is a really serious, grave error of constitutional importance. The jury cannot convict. The jury is not aware enough to convict a defendant if they're not know the elements upon which the Commonwealth is required to prove.
I do have a question.
Yes,
I was
sorry,
gonna
I was
try to
like-
wait for you to finish, but my question is, when you look at Justice Sachs' opinion, you look at Justice Dickoff's opinion, they're using, Justice Dickoff saying, well, you didn't change all that much, really, right? It's the same standard we've always used, but Justice Sachs sees a different standard. Can you articulate for me the difference between Justice Sachs and Justice Dickoff in terms of how they would see and apply the standard?
So, in the way I read Justice Dickoff's dissent was that he was not agreeing that the Savello standard was a continuation of Azar. He was the way I read it was that it was a lowering of the burden of proof for the omission of an element error in the jury instructions. I thought that Justice Sachs was affirming that the Azar standard, the Savello standard, that
The ASOS standard on steroids.
yeah, that's true, he did, yes. And I think he really focused on this court's footnote number 9 in the Savello case. A lot, the cases that the Justice Dickoff used in his dissent really have to do with the word strong evidence and whether or not evidence is overwhelming or whether evidence is strong. As Justice Sachs pointed out in his majority opinion, is that kind of gets us into the sufficiency of the evidence. And just because evidence might be sufficient doesn't necessarily mean that a substantial risk of a miscarriage of justice can occur, especially in the context of this case. He points to the Spinucci and the Vasher case. In Spinucci, it was a footnote 16. The evidence in that case was extremely overwhelming. The defendant's presence was there. Defendant's presence wasn't contested. The defendant himself was armed. There was conversations between the principals and the co-venturer about the knife. And
But
therefore.
a lot of times, judges put in, there's overwhelming evidence because it simplifies the case, right? They're not saying it's required, but it's saying, all right, give me a break. There's so much evidence here, you know, so.
Correct, absolutely, Justice Kaptur, absolutely, yeah. So in this case, you know, where the Commonwealth focused its evidence on this CLI evidence and, you know, the equivocal testimony of Trooper Cardis that the cell phone doesn't necessarily connect with the closest but the strongest tower, given the fact that, you know, there was no identity of the getaway driver, there was no vehicle associated with my client, given that my client was never seen in possession of the proceeds of robbery, he was never seen to profit from the robbery, he was not seen with co-defendants.
What does this have to do with whether he was armed or not?
Oh, well, it has to do with his presence, right? It has to do with his involvement and his presence. So, I mean, you know, as opposed to like the bowling case or, you know, Gorman and Dusudo, like, you're not really quite sure his involvement prior to the case, or the Palmer case, the Massachusetts Appeals Court case. You know, there was contents of conversations with the, you know, co-venturer about what was going on inside the store. There was physical evidence that put the joint venturer in the vehicle, so that there was, you could implicitly find, or the jury would implicitly find that he was aware that they were armed and masked. In this case, without any of that evidence, you don't really have any evidence to implicitly imply or implicitly find that he was aware, if he was involved in planning this robbery or involved in this robbery at all.
I mean, this is an inside job, and he's got a lot of inside information. Now, he may not be the getaway driver, but that's where the armed becomes an issue, whether he's the getaway driver or he's helping provide the information from afar, right? It's better for you. He doesn't, if you're arguing he's not involved, you got an uphill case, right? He knows where the safe is, he knows how many people are there, he's been living in the house, you know, but he may be able to do that from afar. He doesn't need to be the getaway driver, and if he's not the getaway driver, he may not know they're armed, right? That's the best case for you.
Yes, correct. I mean, even if this court did find that the jury had to have found he was a getaway driver in order to convict him, you know, in taking, you know, Justice Sachs' analysis, you know, the conflict he had with the resident, you know, my client clearly thought Victor was a frail man. Maybe he didn't need to think that he needed to overpower him with a crowbar or a firearm or any sort of dangerous weapon. The evidence that the intruders were in the house for some 15, 20 minutes or so before they went up to his daughter's room, there is, you know, can imply that they were looking for the safe and didn't really want to interact with the residents. The fact that everything was carried out in a pillowcase, they could have put the weapons in there, so the getaway driver wasn't aware of them. There's no content in the conversation with my client and the alleged principles involving a weapon or, you know, being masked. So I would say even if this court did find that the jury had to find him as a getaway driver, I don't necessarily know that that would defeat my argument.
If there's a missing element jury instruction and the defendant's theory of the case doesn't challenge that element, what do we do then? Is the substantial risk of a miscarriage of justice analysis different than how Justice Sachs articulates it?
Well, yes, for there to be a substantial risk or any sort of prejudice, right, it has to relate to some aspect of the case, right? You can't just say, you know, well, the error of the case, the theme of the case was that the defendant was, you know, couldn't have the, you know, mental capability to have the crime, but the improper closing arguments had to deal with the sympathy for the victim. That doesn't create a substantial risk. However, in this case, the defense counsel did challenge my client's presence at the scene, did challenge that he had the shared intent and knowledge with the co-venturers. So
Explicitly, he was challenging the knowledge of the firearm and crowbar.
Correct. He wasn't challenged. He didn't say that, oh, this was in I don't know what other theory he could have used, but, this is under duress or something like that. He challenged the sufficiency of his presence at that scene.
Counsel, this is, remember when the Cunene factors were a big deal and we were kind of all, everybody was sorting those out, those weren't elements. Those were evidentiary factors, I think, is how they ended up, what they ended up calling it.
Okay.
That you
So
have to prove beyond a
You
reasonable
had to
doubt.
prove them beyond a reasonable doubt, but they were evidentiary factors. They weren't elements. If one of those had been missing, would we have the same result? I mean, is this similar to that, or?
I mean, if the Commonwealth has to prove anything beyond a reasonable doubt, that is the Commonwealth's burden of proof.
Right.
Here the Commonwealth has to prove beyond a reasonable doubt that they're armed and that he has knowledge they're armed and masked. If you omit that from the jury instructions, whether you call them essential elements or not, that lowers the Commonwealth's burden of proof. By lowering the Commonwealth's burden of proof, you are holding them to a lesser standard than they would be. At that point, if you...
Justice Scalia said you can call them elements, you can call them Mary Jane, it doesn't matter.
It's the Commonwealth's burden of proof beyond a reasonable doubt.
Okay.
If you have no other questions, I rest my brief. Thank you, Your Honors.
And counsel, would you help me with your last name?
Yes, Your Honor. Bodwin.
Bodwin, thank you.
So good morning, Your Honors. May it please the court. Nathaniel Bodwin for the Commonwealth. I believe this court unintentionally changed the standard for evaluating substantial risk in the Silvello case. And I say it's unintentional.
Saying that because Loey's not here.
That helps. But
He's listening, though.
well, Justice Lowy, I say that because of footnote 9 that was discussed earlier, that it stated that we're not trying to change the standard here. But I'll tell you why I think this does change the standard. So for 2 decades, under Azar, the question was whether this error created serious doubt that the trial might have been different had the error not been made. And then courts evaluate 4 factors. One of those factors is the strength of the Commonwealth's case. When you read Silvello, after considering the serious doubt standard, Silvello says, now you need to look at whether this evidence is so overwhelming that there is no likelihood, no possibility, no chance at all that the result would have been different. And I think using that type of language and changing the standard in this context encourages courts to engage in theoretical possibilities, which courts aren't supposed to do when they're assessing whether a substantial risk occurs. And I think that's what happened in this case when it came to whether this defendant knew his co-venturers were armed and masked. When you look in the majority opinion, the court questions whether the intruders planned on using weapons when they entered the home, because perhaps they may have just brought that crowbar in to open up the safe. And that completely ignores the fact that there were zip ties brought with them, which showed that they did expect to encounter residents of the home. The court also questions the fact perhaps Mr. Desiderio, the defendant, didn't think weapons were needed because one of the residents of the home was over 70 years old and apparently had a hip replacement surgery at some time beforehand. But that ignores the fact that they expected at least 2 people to be there, whether they had, their original hips or not, I guess. They also question the fact that this foot-long crowbar, perhaps, maybe, there might be this possibility that foot-long crowbar was obscured by one of the pillowcases that the intruders used to put...
I'm not sure we took the case for the factual distinctions. We're trying to sort through... When you have again, I defer to Justice Gassiano's description of the elements, but if it is a missing element, does that change the substantial risk of a miscarriage of justice standard, and should it, I guess is the question.
No, it should not change the
It's
standard.
different to not have an element in an instruction if it is an element.
I don't believe it should change the standard because the standard has been courts will look at the strength of the Commonwealth's case. So a court can decide whether they want to call it, overwhelming evidence, whether they want to call it abundant evidence, whether they want to call it, as they did in Spinucci, strong.
Maybe. I've done 10,000 SRMJ cases, so I get that part of it. What I don't get, though, is when you have a missing element, the jury has to find the facts, right? so if they're not instructed on the facts, it seems like there's some difference there. I don't know if it's a meaningful difference, but it does seem different than other kinds of unpreserved errors.
I guess what I'm arguing, Your Honor, is the standard should stay the same as it was stated in Azar.
Well, I know your position. I'm
yeah.
just trying to understand is that correct when there's a missing element? Is a missing element somehow different? And then we do have to get into this ineluctable.
Well, I think the standard is the same, but it's applied differently in this context. And that factor, the strength of the Commonwealth's case, would be applied differently when there is a missing element in the instruction. But I don't think that courts should now start with the fact, well, unless this evidence is so overwhelming, there's, excuse me, no chance that the verdict would have been different. I think, and the reason why I was trying to talk about the facts of this case, because I think that those words, so overwhelming, no likelihood, encourage courts to engage in these theoretical possibilities, which is not supposed to occur. And
But even in Azar, I mean, Azar says you look at these factors. The nature of the error here is one of constitutional dimension, the significance of the error in the context of the whole trial, and the possibility that the absence of an objection was a reasonable tactical decision. That's Azar on a jury missing element instruction. So I guess, and Azar also is the case that introduces the, and I can't say this word, ineluctably infer. So I don't understand the Commonwealth's position, because it seems that Justice Sachs was positing these other potential universes of realities because he was trying to answer the question, was it required for the jury to find this element?
well, I think, and I have the same problem saying that word. I think I think it's important to note that
I used
that
overwhelming.
Perhaps, Your Honor. I think that it's important to note that phrase, ineluctably inferred, originated in the Vizcarrondo case, which was a murder case. I believe it was a murder case. I forget whether it was first or second degree, but the issue there was the definition of malice in the instruction. So in that case, the standard wasn't substantial risk of a miscarriage of justice. It was a substantial likelihood of a miscarriage of justice, a standard which is going to be more favorable to a defendant. So I think it's more appropriate in that instance to use phrases like overwhelming, like ineluctably inferred, like the phrase, the evidence required this to happen. And as was discussed,
But we don't get to speculation till we get to preserved error, because that says, would this have been different, what's in the hypothetical jury?
Maybe I missed the question, but you're asking about the sort of the blending the standards between preserved and unpreserved,
Right.
Correct? So in a case like this one, where the error was not preserved, a defendant is supposed to have a higher burden, a higher hurdle to overcome. But what Silvello says is that there is essentially no difference between when an error is preserved or unpreserved. We're going to look instead at whether the evidence is overwhelming. And I did not include this case in the brief, but I did find it when I was preparing. There is an appeals court case, McCrae, and the cite to that is 93 Mass App Court 835. It's a 2018 case. There was a question in that case of whether the error dealing with an omitted element was preserved or unpreserved. So the appeals court sort of analyzed it both ways, and they said, they said, well, if the evidence is overwhelming in this context, then the error is not harmless. Well, then what's the difference? You're essentially creating a standard that's the same, but when an error is preserved and when an error is not preserved.
Is there any chance they were referring to the constitutional dimension of the error with
Well,
regard to it being not harmless or whatever?
Yes, because having it is constitutional in nature when an element is omitted from an instruction. So they are talking about that.
Right. And so what's the standard then, if it's constitutional in nature, not just an evidentiary error?
For an omitted element?
Does it matter if it's preserved or unpreserved?
I think that case simply said, let's say this defendant preserved the error, it's not gonna matter because the evidence is overwhelming if they preserved it. So essentially, there's no difference.
It'd still be harmlessness beyond a reasonable doubt, or?
They said the error would not be harmless because the evidence was overwhelming. Took me a second to get there.
Would be harmless.
Those were the main points I wanted to make in terms of why I believe this standard is wrong, though it was unintentional. I think it causes courts to engage in theoretical possibilities, which they're not supposed to do, and now we have a blending of the unpreserved and preserved error in terms of the standard. If there are no further questions, Your Honors, I can rest on my brief.